Well, welcome. Thank you everyone for joining us this afternoon for our webinar, What Every Educator Should Know About Special Education Law, presented by Beverley Johns. My name is Sharon Larkin, and I am a Senior Marketing Manager at Brooks Publishing. I will be your moderator today, and Brooks Publishing is our proud sponsor for today's webinar. So we are able to offer continuing education certificates for today's webinar. If you're logged into the live webinar, your certificate will be emailed to you within 24 hours. If you're logged in by phone or watching the recording, you will need to be sure to take that CE quiz to get your continuing education certificate. You can find that quiz in the webinar archives folder in the Teaching All Students community located at edweb.net/inclusive education. So without any further delay, I am so pleased to introduce our presenter today, Beverley Johns. In addition to being the author of the new book, Your Classroom Guide to Special Education Law, she also has over 35 years of experience in special education. She ran a public school for children with the most significant behavioral disorders in West Central Illinois and provided consultation to local districts. She's now a professional fellow at McMurray College in Jacksonville, Illinois, and is a learning and behavior consultant. She has chaired legislative committees for a number of professional organizations and was the recipient of the 2000 Outstanding Leadership Award from the Council for Exceptional Children. Beverley, thank you so much for being with us today.
Oh, I am delighted to be here, and I welcome all of the individuals that are on the line with us. So we're going to go ahead and get started. And again, thank you to all of you who are participating, who are continuing your education about learning as much as possible about special education law. As I well know, sometimes it becomes very overwhelming because we think we may know the answer, and then the laws and the regulations change. So we have to become lifelong learners when it comes to special education law. So let's, without further ado, I like to open with this because in so many areas, we've all heard the saying, ignorance is bliss. In special education law, ignorance is not bliss because, in fact, what can happen is it can cause your local school district a lot of money because you said something or you did something that was not correct. So the first thing is all of us have to know the laws and regulations. Now, granted, none of us have such a memory that we could remember them all, but the important thing is that we really need to know how to find the answer because there will be people that will say the law says this, the law says that. And I always say, when someone says that, you need to also look that up yourself and verify it because just the other day I had someone send me an email and they said, their administrator had said to them, there's a new law and it says that we have to collect 10 data points before we can make a referral to special education. And what is that new law? To which I said, there is no new law that says you have to have 10 data points. And in fact, was the administrator had made a decision that that's what would occur, but it in fact is not in the laws and regulations. The other thing that really is very important is that you never fake your knowledge of the information and give out incorrect information because what I find is that more and more families keep up with the latest in special education law. And when we say something that is not correct, that's going to come back and haunt us. Not to mention, we just don't want to be giving out incorrect information because there's a lot of that that goes on as is, and we don't need to be contributing. The information that we give out should be correct. Now, let's look at staying current. Oh my goodness, is that important, but is that difficult? Look at, for a number of years, we had No Child Left Behind. Now we have ESSA, Every Student Succeeds Act. So, and now we have regulations that are coming out about ESSA. So we have to stay current because a law may be in place one year and it's changed the next year. And that really happens in your various states because your legislative body may make changes to special education laws and regulations. So you say to yourself, oh my goodness, this seems overwhelming. How am I going to keep up? Well, the first thing that's important is to have an actual copy of the laws and regulations and to know how to access those laws and regulations electronically. It's a much easier world now because we can access the information. So if we have a question about a letter, for instance, that the Office of Special Education Programs in Washington, D.C. has told us about, we can go online and we can access that information. And it's always important when people say, well, it says this, we need to check it out ourselves. And then I'm a firm believer in engaging in professional development. So that's why I say kudos to all of you who are really working to learn more about special education laws and regulations. And it's also important to stay involved in your professional organizations because they keep you current with what is happening. So you can also participate. There are some wonderful blogs out there. There are some wonderful electronic newsletters. So the important thing is that we read and we access information and we talk to individuals just as much as we can so that we know when there are changes made or we want to verify certain information that other people have told us about. So let's just take a minute or two and you just think about how many of these acronyms that you know, because I think in special education, not just in special education, it's in all other fields as well, but we have our own vocabulary. And we have to remember that because we know the vocabulary, maybe some other people don't understand it, but just take a couple of minutes to see how many of these acronyms you know, and then we'll talk about what those acronyms stand for. Okay, wonderful. I saw at least one person who knew them all except for FERPA. So let's go through these and see how you did. I think if you knew 6 of them, that's absolutely wonderful. FAPE, of course, stands for Free Appropriate Public Education. And all students with disabilities have the right to go to school and receive an education that is both free, appropriate, and it's a public education. And IDEA is the name that we use, and it's the Individuals with Disabilities Education Act. And that was last reauthorized in 2004. And now that we have the reauthorization done on the Every Student Succeeds Act, ESSA, the work probably will begin on the IDEA reauthorization. So FERPA, some of you didn't know FERPA. And FERPA is a very important law because what it does is it protects the right to privacy of students and their records. So it deals with confidentiality, and it stands for Family, Educational Rights, and Privacy Act. So it's the Family, Educational Rights, and Privacy Act. And it deals with, and we'll talk more about that, it deals with the difference between permanent records and temporary records. It deals with who you can disclose information to and who you can't disclose information to. And BIP, of course, which is a topic near and dear to my heart because I've worked with children with significant behavior challenges most of my career, is the Behavior Intervention Plan. And we're going to talk more about that. And LRE. And I'm going to, in this webinar, we're going to talk about the 4-pronged test for least restrictive environment. And the ADA is the Americans with Disabilities Act. And CAP is the Continuum of Alternative Placements, meaning that school districts are supposed to have options, plural, for students. So they cannot say if the student has a learning disability, they're in this placement. If a student has behavioral disorders or serious emotional disturbance, they are in this placement. You have to have options for students. So CAP again is Continuum of Alternative Placements. And so now let's look at the whole situation with the laws and regulations that all of us need to keep current with. First of all, at the federal level, we have the Individuals with Disabilities Education Act, that is our special education law that governs what we do with students who have been identified as having a disability that adversely affects their educational performance. And then we also need to know about Section 504 of the Rehabilitation Act of 1973, because the bottom line is that is an anti-discrimination law. And it says we cannot discriminate against someone because of their disability. And then the Americans with Disabilities Act covers the rights of individuals with disabilities in the workplace, in other public settings, and certainly school districts must follow ADA because they have to follow those requirements about both physical accessibility and other types of accessibility within the school. And the last one is FERPA, the Family Educational Rights and Privacy Act, which governs how we integrate records and how we handle records. Now you say, well, that's enough laws and regulations to keep up with, but oh, not so, because in every state, there is a different set of state laws and regulations. What we know about our state laws and regulations that govern special education or anti-discrimination or records is that state laws and regulations cannot do less, but they can do additional requirements on top of what's being done at the federal level. So they can add to federal level. So I always say to people, the best place to find out where your state laws and regulations are is to look at your State Department of Education's website. And again, go to your professional organizations, because they can also help you access that information as well. And again, state laws and regulations can go beyond federal, they cannot do less. And then you say, oh, this is enough, but not the case, because there are many instances where I can read the federal laws and regulations one way, and you might read them another way. And that happens more than you think. And then what happens is somebody says, I think it says this, and the parent says, no, I believe it says this, and I want these services for my child. And the school district may say, no, those are not appropriate. And when there is a dispute about what the laws and regulations say and what might be an appropriate placement for a child, then we go to due process and ultimately to the courts. And if you've been following on a variety of blogs and newsletters, you know that we have currently a case pending in the Supreme Court that deals with service animals. And you may have seen the picture of the golden doodle, because it deals with a golden doodle and whether a golden doodle can be within the school and come to school with the child. So we have a case going to that is in the Supreme Court. And then we have Office of Special Education Program letters. Those are letters that when there seem to be some problems with clarification about the law, and the Federal Office of Special Education Programs is getting a lot of complaints, they will issue a letter that will help people better understand exactly what the laws and regulations mean, and when the law was passed, what it meant to say. So those are all the various laws and regulations that we need to stay current with. Now, think about these. Which of these components are included in Section 504 or IDEA? And I've given you 4 options. So in which law would you find listed 13 different types of disabilities? Okay, and if you said IDEA, which the majority of you did, wonderful, because the Individuals with Disabilities Education Act provides a list of 13 different types of disabilities. Okay, terrific. Let's go on to the next one. Which of the laws talks about comparable education? Section 504 or IDEA? Okay, terrific. A comparable education to the education of other children is what Section 504 of the Rehabilitation Act of 1973 says. Now, what does that mean? We always get the question about sports, and can students with differing disabilities participate in sports? The issue is, what do the other children who do not have disabilities get? What is the comparable education or the comparable role of extracurricular activities? So all students would have the right to go out for sports. That would be comparable. So children with disabilities have the right to go out for sports. Children have the right, all children have the right to access the school. So that's a comparable education. They have the right to get in the classroom door. And students with disabilities also do. And so that deals with the issue of physical accessibility. The children have to be physically able to get in the school door because that would be a comparable education. How about an IEP? Is that in 504 or is that in IDEA? Ah, terrific. And everybody said that is the cornerstone of the Individuals with Disabilities Education Act, is the individualized education program or plan for each student. So that is individualized. So special education differs from Section 504 because 504 is talking about a comparable education to the other children. IDEA is talking about what does this individual child need. And how about our last one, which is birth to death? Is that 504 or is that IDEA? And it is Section 504 because Section 504 is going to protect an individual who has an identified disability that impairs a major life function. Section 504 has a broader definition of what a disability is, and it covers essentially the lifespan from birth to death. So that's why we have separate parking places. We have sign language interpreters, not just for the children within the school, but also their families, if their families wish to go to a public event. So, okay, that's wonderful. Okay, now I always say it's like cherry pie, and you're saying, what does cherry pie have to do with special education law? Well, here's my analogy. The law itself forms the bottom crust of a pie. All of us love pie, but most pies have a bottom crust, and that's the foundation, that's the law. And then when the law is passed, there are some issues that aren't as clear as they should be in the law. So we fill it in with cherries, and the regulations are the filling to the cherry pie. And then even when we have the laws and we have the foundational crust and we have the cherries in the pie, we still have some unanswered questions, which is why we have court cases, and those make the top crust of the pie. And the court cases answer a lot of questions for us. But by golly, if you've got a slit in the top crust, because there may still be some questions unanswered. So that's my analogy about laws and regulations and cherry pies. So let's look at the roles and responsibilities of IEP team members, because I always say to people, take that responsibility seriously, because when you are part of a meeting about a child's special education, you are making decisions that impact that child's life. And so they're very serious decisions. And sometimes we say, oh, I have to go to another IEP. The bottom line is those IEPs are very, very important. We need to take them seriously, and we need to have done adequate preparation, because when we go to an IEP, we come in with evaluation instruments, various evaluations we've done. For instance, we may be an observer of that. We may have collected observational data about the child. We may have done some individualized assessment. We may have looked at how the child compared with other children on whatever test the school district is using. And we're a required IEP team member and contributor. One of the most frustrating things, having participated in thousands of IEPs, I would see people come into the IEP as a required member of the team. They wouldn't say anything. The team would decide something, and then they would get out of the meeting and say, well, I really didn't agree with what was done. And the whole point is, then you need to speak up, because you are a contributor. Otherwise, you wouldn't be in that meeting. Then, once you have decided all of those, what the child needs, you're an implementer of the IEP. So if you're the general education teacher, where the student spends the majority of their day, you're going to be implementing the IEP. If you're a special educator, you're going to be implementing the specially designed instruction. If you're a social worker, you're going to be working together to meet the social emotional needs of the child. And then identifying the supports that are needed for the student. And we say be really careful, because the evaluation process is an ongoing process. And so we need to identify the supports. And let's say the student is still struggling, then we need to look at, are we providing adequate supports not only to the child, but to the teacher, so that the teacher can meet the needs of the student. And the bottom line is we also monitor that IEP to make sure that what's written on the IEP is what's being done. And remember, our required participants in the IEP process are the parents. The parents are an integral part of the team. The parents are evaluators. They know their child better than anyone does. So they are part of that evaluation team, and they bring to the table, what can that child do at home versus what can the child do at school? And they provide relevant information for us about medications, about social issues, about some of the things that the child may be going through. So the parent is an integral part, the student where appropriate, the general education teacher, the special education teacher, and someone who can commit services, which would usually be the building administrator. So those are the required participants in the IEP. And there may be a number of other people. There may be the school psychologist, the school social worker, the occupational therapist. But the bottom line is, required are the special educator, the general education teacher, the parent, someone who can commit services, and someone who can interpret the instructional implications about the IEP. Certainly, a number of other folks can be involved as well. Here are the areas of concern. One is that we had talked a little bit before we went live online about there is no such thing as unilateral action in special education. And that's a very difficult concept for some individuals to understand. So, when we're going to make decisions about the placement of a student or anything that impacts the individualized services that we're providing to the child, the IEP team makes the decision. We don't make it unilaterally. And we also know that the IEP has to be followed. So the individuals who are implementing the IEP need to have a copy of the IEP. Certainly the parent has a copy of the IEP. Anyone who's implementing or needs to have it. So that IEP is placement, it's accommodations, whether the student needs a behavior intervention plan, and what is the parent involvement. Because good IEPs talk about the strengths of the child and they must address parental concerns. So when parents come in, not only do we need to make them feel very welcome in the process because they are such a valuable resource, but we also need to talk about what are the parents' concerns. What are they concerned that their child needs to know or doesn't need to know? Now, we need to beware of the failure to evaluate students because we're going to talk about a letter that was issued by the U.S. Department of Education in the Office of Special Education Programs. And we hear of school districts. So remember, I gave you the example of the person saying, we're told we have to collect 10 data points before we can refer a child to special education. The bottom line is, if you have knowledge that a child has a disability, or you have suspicion that the child has a disability, you must evaluate the child. Because sometimes what occurs is that they will say, well, we require the child to go through response to intervention, RTI, or we require the child to go through MTSS, be multi-tiered systems of support before we evaluate. If we have knowledge of or suspicion of a disability, we need to evaluate the child. The other thing that I think sometimes happens, I know it happens, is that we fail to recognize independent evaluations. So let's say that the parent has had an independent evaluation done, and it showed that the child was ADHD, and the parent brings the evaluation in, and the school district says, "Oh, well, that's fine. We'll put that in the file." No, the school district has to recognize that evaluation in a team meeting. They don't have to accept it, but they must recognize the evaluation. And then we know that our evaluations have to be multidisciplinary, meaning they need to be done by at least 3 people. And we can't ignore the timelines for an evaluation. Our federal law provides us with timelines for when an evaluation has to be done from the time there was parent permission. And then some states go beyond that. So this is an excellent example of where you have to not only look at the federal guidance of the federal law, but you also have to look that your state may have an even stricter process for when you evaluate the student. Here is the Office of Special Education Programs letter that was issued to school districts on January 21st, 2011, because there were so many school districts that were saying the children have to go through RTI. And in the case of one instance, I knew the child had been in the response to intervention process for 4 years and was not evaluated. What happens is you never recover that 4 years, and the student had a clearly identified disability, but yet they made the student go through response to intervention for that long of a period of time. OSEP said you can't do that. And then here is another issue, which is one size doesn't fit all. And you say, what do you mean by that? I mean that sometimes we fail to individualize for the specialized needs of the child. We had a court case some years ago in a southern state. It actually could happen any place where when the hearing officer looked at the IEPs for the children, the hearing officer found that every child in the classroom had the same goals. That's a problem because that would say you really haven't individualized, and we have to remember what the I is in the IEP. I know that a lot of people utilize computerized IEPs. Probably most school districts would use computerized IEPs. And they may be wonderful, but we have to be careful that they're individualized. You have to be alert to problems with checklists, because here's what sometimes happens. The school district will say, well, we have an accommodations checklist, and so I'm not really sure what the child needs on the checklist, so I'll just check everything off. Well, that really doesn't tell anybody who's looking at that IEP what are the accommodations that are meaningful and individualized for the students. And the bottom line is special education is about specially designed instruction. A whole nother topic is this whole issue of we make accommodations for children, which we should. But if the child cannot read, and we say we're going to accommodate by reading information to the child, but we don't teach the child to read, we have done a real disservice to the child. So that, yes, we accommodate, but we also say to ourselves, what is the reading approach that that individual child needs that will result in him making benefit in reading? And then individualize. And you say, what on earth is PLAF? It used to be PLOP in the old IDEA because it was present levels of performance. But when IDEA changed, it became PLAF, which is present levels of academic achievement and functional performance, and goals and objectives and placement. This is an area where some states only do goals because IDEA requires goals, and IDEA requires objectives for children who participate in alternate assessment. But many states require both goals and objectives for students. So, and the whole issue of placement is also important, that we never can say all children with behavior problems go to this placement, because that's not individualized for children. This is what special education really is, meeting the individualized needs of the child. And first and foremost, it's specially designed instruction that's delivered by the special educator, and it's based on a thorough assessment of the child. It may be remediation, it may be compensation, and then it may also be related service. And then because many of our children are in the regular education environment, the classroom teacher needs to differentiate to involve all of the students. So that's delivered by the general educator. And then accommodations and modifications, and the term is reasonable accommodations. So we cannot expect a child or a teacher to make accommodations that would require them staying up all night doing that. These are reasonable accommodations, and they're delivered within the general education classroom. And in good settings, they're both the responsibility of the classroom teacher and the special education teacher, because we need to collaborate. So, okay. Now, when we're talking about placement of children, we say, how do we determine placement? Actually, back in 1994, We had a court case that came from California, and I know we have some California participants on the webinar, and that's wonderful. And in this case, this was a little girl, and her name was Rachel, and Rachel was a young lady, and Rachel had intellectual disabilities. And Rachel's parents wanted her to spend time in the general education environment. And the school district said no. And the parents said, but we want our child to be around children who don't have disabilities. And the school district said, well, here's what we'll do. We'll have her part of the time in general education and part of the time in special education. So little Rachel is going back and forth between special education and general education numerous times in the day. And her parents said she's losing instructional time doing this. So what happened was the Ninth Circuit gave us a test, and a lot of the other circuits have used that. And the first question we need to ask is, when we're deciding on placement, will the student derive educational benefit from the placement considered? And the second question is, will the student derive non-educational benefits? So the example for Rachel was that she could have friends in the general education classroom. She could have excitement for learning, improved self-confidence. Now, the third prong of the test was, will it be detrimental because the student is disruptive to other children? And is the student taking up too much of the teacher's time so that the other students would suffer from lack of attention? In the last prong of the test, and you'll say, my goodness, I can't believe you can actually consider cost. But yes, the answer is you can consider cost. Now, when the courts applied this four-pronged test to Rachel Holland, they found that she could derive educational benefit from the general ed classroom. She could also derive non-educational benefit. Rachel was not a disruption because she did not exhibit behavior problems, and the cost of educating her in the general ed classroom was not too much. So now keep that four-pronged test in mind as we moved to the next one, which was in the same circuit. In the Ninth Circuit, there was a young man in the state of Washington. And this young man, it was a different story because Ryan was causing disruptive behavior in the general education classroom. Now, important in this case is that this school district was really working very hard to provide all of the supports that this child needed in the general education classroom, and it still was not enough. So the courts ruled that his disruptive behavior kept him from learning, and he had an overwhelmingly negative effect on teachers and other students. And the court said the third prong of the test, the four-prong test, is that the third prong will take precedence. But always remember, this was a school district who had made every effort to provide supports in the general education classroom. So the school couldn't just say, well, we won't do anything, and he should be in a separate class because he is causing too much disruption. The question would be, well, what have you done to show that you were trying to meet his needs in this setting? So now let's talk about collaborating with families, because the bottom line is that we need to work together with families. And we need to understand the needs of the family. I always say it would be very easy for us to criticize families, and the bottom line is we do not live with the children. And so we don't live with the children, and the parents may work and come home, and there's a lot of stress on the parent. And so we need to understand that there is a lot of stress on the parent and be very cognizant that we're not being critical in blaming some of the things on the parents. We need to work collaboratively with the parent. And then we need to recognize their expertise. They know their child. And we need to, it's just like our students. We recognize, hopefully, none of us ever take good behavior for granted. We recognize it. That's the same thing with families. Everything that that family does that's positive and that is truly collaborative, we need to let them know that and accept that fact and tell them how much we appreciate their partnership. And then we need to respect the right to disagree, because we may think we have all of the answers, and we may think that we know what's best for their child, but they may have another idea. But we need to come together to see what our common ground is. And then a lot of our children coming into schools today need other types of services. They may need mental health services. They may need additional support systems, and we need to link them to those services that are available. I was just presenting on trauma informed practice in the schools, and we were talking about, as I told you, I live in the state of Illinois, and it's rough because a lot of our human services programs have been cut. And so we're trying to link parents to services that may or may not be available because of budget cuts. And the next thing, the last one, is to seek their input. So we do things like homework evaluation sheets. Be very careful of giving children homework that they cannot do independently, because the bottom line is, if the teacher doesn't have if the parent does not have the teacher's manual, they may not know how to do the homework either, because we have a lot more expectations in schools now. We have to be very careful with home notes. I was called into a school that it was, they were about to go into due process, and they were about to go into due process over home notes, because the teacher was being very negative in the home notes. Well, the parent was stressed enough, and the parent actually dreaded getting the home note, because the home note said what the child couldn't do, as opposed to saying what happened at school that day. So if you frame home notes, which I'm a firm believer in those communication systems, but if you frame home notes about what happened at school that day, then the parent can talk to the child about what happened at school that day. I often understand why some parents don't give their phone number to school personnel, because if their child has a behavior problem, they don't want to hear from the school, and they dread the home notes. So we have to carefully frame how we present information to families to not become negative. Oh, okay. So you've been listening a while. Let's do a 2 truths and a lie. So one of these statements is a lie, and which one is it? The first one is, if the parent can only attend an IEP on Saturday, then the school district must schedule a meeting on Saturday. And the second one is, under certain circumstances, the school can hold an IEP if the parent can't attend. And the third one is, parental concerns must be addressed at the IEP. Okay, terrific, terrific. It's true. If the parent can only attend an IEP on Saturday, then the school district must schedule the meeting on Saturday, not. Because the law is very specific that we schedule IEPs at a mutually agreeable time. So most educators would say Saturday is not a mutually agreeable time for me. So that's where, if you have a collaborative relationship with parents, you won't have those issues, because you work together, you value their time, they value your time. So, and number 2 is correct. That's true, because under certain circumstances, the school can hold an IEP if the parent can't attend. However, just make sure that you, as school personnel, if you're school personnel participating, that you have written documentation that you have made every effort to get the parent there. And generally, the rule of thumb is you at least have 3 sources of written documentation. You send the letter, you may then follow up with a phone call, and maybe you follow through with another note. So one of the examples I use in the book was that there had not been any type of, shall we say, effort to find out the correct address of the family. And what was being done was the form was being sent to a wrong address, and they sent forms, and they did it 3 times, but they sent it to a wrong address because they had failed to realize that the parent had moved. And lastly, parental concerns have to be addressed at the IEP. So again, the IEP is a team effort. And we talked about there is no such thing as unilateral action in special education. Okay, look at these. Look at number 1. The principal decides the testing accommodations. Is that right or is that wrong? Ah, very good. It's wrong. Who decides the testing accommodations? That is the IEP team. And they have to know as much as they can about the student. And incidentally, testing accommodations should be comparable to accommodations that are done in terms of instruction, because we don't suddenly introduce a new accommodation when the child has not had that within instruction in the classroom and the child has not been taught how to use the accommodation. All righty, let's look at the second one. The teacher changes the time the student sees the speech and language pathologist. Is that right or is that wrong? And that would be right too. That's wrong, because I don't think that a speech and language pathologist would be happy if the teacher just changes the time. And again, let's say that the child has speech and language for 40 minutes a week, and the teacher says, I don't really want to let him go to the speech and language pathologist except for 20 minutes. They can't do that. That's a collaborative decision through the IEP. So the teacher sends a student home for the rest of the day because of the student's behavior. Okay, that is also wrong. And why is that wrong? Because the bottom line is that's a suspension. And I can't tell you the number of times I was called into another school where the teacher had been sending the student home. The principal had not been informed. The principal was suspending the student sometimes. The teacher was sending the student home. The assistant principal was sending the student home. By October, there were 15 days of suspension. A problem. That is a suspension. So the importance of, so when we look at the IEP, we're looking at the student, their background, evaluation results, strengths. This is always strength-based. And sometimes when we're working with children with behavior problems, the bottom line is you'll say, tell me what the student does well. And people will say, I don't know. Well, every child has strengths. And if we really talk about the strengths in the IEP, we go a lot further in collaboration with the family, because the family doesn't want to come into a meeting where all they ever hear is what their child cannot do. They want to hear the good things that the child can do. So from that, we then do present levels of achievement, academic achievement, and functional performance, everything written in MOO terms. MOO is measurable, observable, and objective. And we'll talk a little bit more about that, goals and where appropriate objectives, depending upon the state you're in, and then where and how can the child's needs be met. So we look at where the child is, we look at where we want the child to be, and then we look at where and how can we meet those needs. So let's look at these. Are these statements written in measurable, observable, objective terms? Dakota is truant. Right. That is not measurable, observable, and objective. I always say, too, a stranger should be able to pick up, like a new school district should be able to pick up the IEP and say, I know exactly what that means. The child has missed 10 of 35 days. That's mood terms. Dakota is truant, is not. We don't know. And if a child moves from state to state, it may very well be the truancy in one state is different than it is in another state. How about this one? Kiara can't read. I just heard this one the other day from somebody. I said, what do you mean? That's right. That's not written in measurable, observable, objective terms. What would be better to say would be Kiara's reading comprehension is at mid second grade level, or Kiara's word recognition is at the second grade level, so that I know exactly what's meant. And the last one, Blaine has weak math skills. And you're absolutely right. What I need to say is, exactly, does Blaine have difficulty with multiplication? Does he have difficulty with word problems at the fourth grade level? I need to break it down as much as I can so that when a stranger would pick up the IEP, they should know exactly what I mean. So now let's look at the lingo of behavior interventions. Look at these and just jot down any of them you don't know. Well, this is good. Everybody knows these? Okay. Very good. Okay. We have lingo in the IEP process, and we certainly have lingo in behavior interventions, don't we? So the BIP is the BIP, the behavior intervention plan. The FBA is the functional behavior assessment. That's what we do before we do a BIP, because we need to assess what the student, what is the function of the behavior, and what are the multitude of issues that could be impacting. And we can't do a good BIP if we haven't done a functional behavioral assessment. MD is manifestation determination. What we do when a student engages in a behavior and we believe, and we're going to have to try to find out if that behavior was related to the disability. PBIS, some of you probably are working in PBIS schools, and that's positive behavior interventions and supports. And SWPBIS is what we use as school-wide positive behavior interventions and supports. And the last one is ABCs, which is all part of the whole notion of behavior, which is what happens before the behavior occurs, what is the behavior specifically written in mood terms, and then what happens after the child behaves in a certain way. What is the consequence? So let's look at the key points. Do we only do BIPs if the child is receiving services for having behavioral disorders or serious emotional disturbance, whatever term your state uses? No. We do a behavior intervention plan anytime behavior is interfering with learning. It's always based on the FBA, and we're always monitoring the days of suspension so that we're never going over 10 days a year. And one of the positive things is I'm seeing more and more states actually adopt laws that would say that you cannot be suspending children, because in fact, the majority of suspensions are for defiance of authority. They're not going to be they're not for dangerous behaviors. So we need to monitor and look at those behaviors. Okay, so let's talk about I didn't see it happen. One of the things in today's world is that we have to provide adequate supervision of children, because if we don't always see what has happened. And let's look at the issues with paraeducators. The teacher is ultimately responsible for the education of the students in his or her class. And the teacher is supervising the paraeducator, so the teacher needs to know exactly what the paraeducator is doing, because the teacher is the one who's supposed to be planning the instruction. And then issues with bullying, we need to pump up supervision, and we need to not ignore aggression. And sometimes I think that we don't want to see things that happen. We think if we just act like we didn't see it, maybe it will go away. In fact, it will not go away, it will get worse. Field trips, hallways, cafeteria, recess, technology, we really have got to pump up our supervision um, of students so we know what's going on at all times. And remember, if it isn't written down, it wasn't done. Because a lot of people will say, well, I told somebody about this. Well, did you do a follow-up in writing? And the issue is, if you didn't, you have no proof that you actually did. So I always say, document everything in writing. So the event happens, or a request is made. Let's say you're a teacher and you believe that the child has or may have a disability. So you say, I believe the child needs an evaluation. You can talk to someone about that, but then you need to put the information in writing so that you have proof that you did something. We talked a little bit about this. This is what I call the stranger test, which is portability. Remember that a lot of our children move around, and therefore our document needs to be portable so that someone can pick it up and know exactly what's going on. We also need to be very objective, no opinions. Well, I believe his mother is this. On what information do you base that on? And then a record is anything that's shared with someone else. So FERPA is temporary records versus permanent records. And it deals with private files. And remember that anything that is shared is a record. And then it deals with destruction of records. And it says that the parents have the right to the records, and that all school districts need to know who their records custodian is. So is this a permanent record or a temporary record? We're out of time, but let's just talk about these. Are grades a permanent record or a temporary record? And they would be a permanent record because the records are kept a long time if they're a permanent record. Special education evaluations would be a temporary record. School districts can give notice and get rid of those records generally after the student has been out of school for 5 years. And a 504 plan, because it would designate a disability, would in fact be a temporary record. So special education evaluations, 504 plans, those are temporary records. Grades and basic identifying information such as birth dates, they're permanent record. They last for many years in a school district. And last, the special education classes taken, that's a temporary record. Nothing that talks about special education can be in a permanent record. Temporary records are destroyed after 5 years, generally, but there has to be notice that they're going to be destroyed because the records actually belong to the student and the student's family. So presenting a positive image, what do we need to do when we're working with children and with disabilities? Check and recheck anything sent to someone else so that it can't be misinterpreted. Share only with those who need to know, and avoid any negative statements about our profession and individual children. We hear so many people that bash the educational profession. We need to stick up and make positive comments about what we're doing with students in the schools. So, one more, 2 truths and a lie. Which one is the lie? Is it number 1? Is it number 2? Or is it number 3? Oh, terrific. Absolutely. It's number 2. What an employee posts on Facebook is no business of the school district, and yes, it is. And in today's world, a lot of administrators are looking at the Facebook post that educators do. I say to individuals, remember that as an educator, if you're an educator, you're a public servant. And we don't put anything on Facebook that we don't want the whole world to see. And off-duty conduct this is true, can be considered when determining whether an individual should be reemployed. And educators are not always protected by the Constitution's First Amendment of freedom of speech. We're seeing more and more cases where teachers have said things that may have been derogatory to the school district and therefore have caused problems in their everyday work. So, what is our role in moving forward? We need to ask ourselves, are we keeping abreast of new laws and regulations? So, as ESSA evolves, we need to make sure we know what it says and what the implications are for students with disabilities. When there is an IDEA reauthorization, we need to make sure we're keeping abreast and we're giving input. Are we putting the needs of our students first? And are we effective collaborators? So I thank all of you for being on the call and hanging in there with us. I believe we can take a few questions. Am I right?
Yes,
Oh,
absolutely.
wonderful.
We've got a bunch.
Wonderful.
Yeah, great job, Beverly. Great
Thanks.
job. The chat has gone crazy and it's been fantastic. So let's just jump right in. We'll go a couple minutes over. Many people ask, what's the easiest way to stay current with laws?
Okay. And again, now I think that it's easier because we have so much access to technology. I encourage people to join blogs, to join blogs that deal with special education laws. I also encourage people to stay current with whatever their organizations are. So we had some parents on the line. We have a number of parent organizations. We have for educators, we have a number of professional organizations, and those organizations send out regular updates about the laws and regulations. And your state organizations will do the same thing. And you have to read because, again, we've got to be knowledgeable about what is happening. And I think with technology, it's actually easier. Sometimes we get overwhelmed, but we can get on as many lists as we want because we can always, look through them and see whether there are any that we're particularly interested in.
One question that just popped in, what's the impact of these laws and regulations on private schools?
Well, IDEA has a whole section on our private schools. And first of all, Section 504 of the Rehabilitation Act says you can't discriminate against anyone with a disability. So people will say, well, we're a private school and we don't have to do that. The minute a private school takes 1 penny of federal money, they must abide by the laws and regulations for Section 504 the Section 504 of the Rehabilitation Act of 1973. So they have to do that. Now, there is a whole section in the law that talks about individual service plans so that if children are going, for instance, to a parochial school, but their parent wants them to receive some special education services, then the parochial school together with the public school can come together, have a team meeting, and create a service plan if the parent wants the child full-time in the parochial school. However, what also happens is there's something known as dual enrollment. Some parents opt to say, I want my child to go part of the day to the special education program in the public school, but I also want my child to be in the parochial school. So that's kind of a thumbnail sketch. But now the service plan does not provide a lot. for students. They're not going to get what they would get with an IEP, but that's really a decision that parents have to make. How important is the parochial education versus how important is the public school special education? I see a number of individuals who work in parochial schools who really make every effort possible to learn as much as they can about students with disabilities. So that's very positive also.
Okay. Does 504 guarantee accommodations in adult education?
It guarantees reasonable accommodations. And the issue is for adults, the individual, which is why it's really very important for us to explain to our students before they ever leave the secondary program what their disability is, what it means to them, and what accommodations they will need in the real world. Because we, as the primary and secondary educators, are not going to be with the students who go on to like the post-secondary world or who go on to a job. But the encouraging thing is more and more of our students are going on to post-secondary education. And yes, post-secondary programs generally have a disability services coordinator who can help those individuals access services, and individuals cannot be discriminated against based on their disability in the world. And hopefully in the secondary program, we have worked with the students to talk about what are appropriate work placements if they don't want to go on to a 2-year or a 4-year college or a vocational training. If they want to get a job, we want to advise them on what kinds of jobs they may best be suited for.
We had many questions when you were talking about the IEP team,
Mm-hmm.
about parents, the parents' involvement, and kind of
Mm-hmm.
the running theme is if parents are part of the IEP team, what if they do not agree with what the team decides at that meeting?
That's a really good question. And the bottom line is if they don't agree, the school can't do the placement. That's one of the
Okay.
things that during my career I have seen change, because at one time, if the parents said, I don't want placement, you said, okay, we will not provide services. Then there was a period of time when if the parents wanted to revoke placement, they had to go to due process to revoke placement. Well, then now it has changed, and it's that if in fact the parent says no to the services, you can't engage in the services, which is why we really need to work collaboratively with parents, because oftentimes we'll find out we don't know the reason the parent doesn't want the services. And if we're able to talk together with the parent, we might be able to find out what their thoughts are about why they don't like the program, and then can we work to develop something different.
Okay. Um, Kind of going on the flip side of that, and I'm just looking for my question here. How does one advocate for an already classified student who has poor parental support and child apathy, which seems particular or partially a result of feeling hopeless?
Oh,
Kind
so
of the flip side.
the
Yeah.
family feels hopeless, the child feels hopeless. The family may be dealing with a lot of stressors, and I think I have to go back to trying to find what we can do in terms of the support to parents. Obviously, I spent a lot of my career, and by the time I would get the students in some of our programs, the parent had a very negative response, and we had to build on everything that the parent did that was right. And we had to give the parent hope. I mean, we had to call the parent on the phone and say, I really appreciate the way you got your child to school today. Or I really appreciate the way you did this. So just like with our children, we need to use positive reinforcement. We need to look for everything that the parent does that's positive. And we need to give the parent access to some services that if they're feeling hopeless, they can be overwhelmed. Parenting a child who has a disability, uh, has a lot of challenges. We have, I can say personally, we had a neighbor and she has two children who have autism spectrum disorders. And one of the children would run out of the house with no clothes on, and he was getting older, and so then she had to work with the police department, because otherwise they're going to pick up this naked child. Can you imagine the stress on the family?
Yeah, that's a lot of
Or a
stress.
family goes to a hotel and they have a child with a disability. In another case I knew of, and they kicked the family out of the hotel because their child had significant emotional issues. That's not easy for families.
You're right. It's a good point. You need to
Mhm.
positive behavior supports for parents as
Right,
well.
absolutely. It's
Absolutely.
so true.
Yeah. So I think we have time for one more question. We do have a bunch of questions. So what we can do, I will go ahead and send these to Beverly after the webinar, and then we'll post them in our webinar archives section so everybody can read through them. But just to end this, how do we deal effectively with the cliff that some students fall off when they're dropped from special education services and are just thrown into regular
Um,
education with no classroom support? That's a great question.
It's a wonderful, wonderful question, and it's the responsibility of the IEP team to still monitor those services. They can't say, well, he's out of special education, he's no longer of concern to us. No, that child still needs support. So in that IEP, we should have built in supports in a transition period of time, and a period of time where we truly monitored how the child was doing so that the child didn't fall off the cliff. I think that's the responsibility of the IEP team, to look very closely at how we transition children out of services. And we don't just do it, we in fact come up with a clear plan to monitor and to transition from the services.
Wonderful. Well, thank you. I cannot thank you enough, Beverly, for being with us today. Fantastic job
Oh,
on your
thank you.
presentation. I will send you all of these questions that we didn't get to, and then we
Okay.
can post them in our community. Thank you, everyone, too, who attended. I know you guys are very busy, and it takes a lot, to take an hour of your day and spend with us, and we greatly appreciate it. Be sure to write down your discount code at WebLaw if you are interested in getting a copy of Bev's new book. Also, do not forget about your continuing education certificate. Everybody who attended live today, it's going to be emailed to you. And if you joined by phone, just make sure that you take the quiz in our community on our community site. And also, please, be on the lookout. We're going to be adding Brooks Publishing, Teaching All Students, EdWeb community. We're going to be adding our 2017 webinar schedule soon. So you'll want to be, tuned in to see what we have in store. On behalf of Brooks Publishing, EdWeb, and Beverly Johns, thank you everybody so much for attending today. And I hope you enjoy the rest of your day.
Thank
We'll see you
you.
next time.
Thank you, everybody.